Hi. Welcome to the fourth episode of our talks about distribution agreements worldwide, dedicated to Germany. Our speaker today is Julia Blind, our expert based in Stuttgart, interviewed by Roberto Lucy Crivellini. In this episode, they'll discuss how distribution agreements are regulated in Germany, what are the important clauses in these agreements, what are the main issues in distribution agreements, and how to prevent or manage conflicts. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Hello, Julia. Thanks for joining us on this fourth episode of our distribution series, where we talk about distribution agreements worldwide, in this case for Germany. Thanks for joining us. And I would start right away by asking you, how are distribution agreements regulated in Germany?
Nice to meet you, Roberto. I'm very much looking forward to our distribution talk. Coming to Germany. Although the German Civil Code and the German Commercial Code regulate different types of commercial contracts, such as a lease agreement or purchase agreement or agency agreements, distribution agreements are not subject to any particular statutory provisions in Germany. According to German law, a distribution agreement may broadly be described as a framework contract by which the distributor undertakes as an independent entrepreneur to sell goods and render services. I think this is the understanding in all other countries as well. The distinctive element of a distribution agreement is that the distributor purchases goods at a discounted rate from its principal and then sells the goods in its own name and for its own account on a regular basis to its customers. So there is the difference to an agent who sells the products not in his own name and for its own account, but the principal sells the products. So the distributor gains the profit from the margin between the purchase and the resale price. As the distribution agreements are not explicitly governed by statutory law, it sometimes is difficult to determine which specific legal provisions are applicable. And this must be done by a determination on a case-by-case basis. In principle, the general rules provided by the German Civil Code with respect to contracts, and especially this special type of contract for the performance of continuing obligation will apply. But sometimes the provisions governing agency agreements may apply. But then by analogy. And this requires that the distributor is integrated into the principal's sales organization. So this means that the distributor must be in a very similar position like an agent. Yes, and the crucial duty to consider is whether this distributor is obliged as an agent is, because he does not sell in its own name and on its own account, to forward the customer data to the principal during or upon termination to the principal. And in this context, it is irrelevant whether such a duty to transfer the customer data is explicitly agreed or factually. So this as a general overview on the law governing distribution agreements in Germany.
All clear. Thank you. And that's, in fact, good to know, as it's often the case that you might even have a mixed agreement whereby the distributor slash agent undertakes to perform both obligations, and depending on the client, it may act as a buyer reseller or as an agent. So it's good to know that you have to pay attention on whether or not the data of the end customers are at some point transferred to the principal or not, whether it's explicitly foreseen in the agreement or de facto. So thanks for pointing that out. That's a very good point. My second question would be, based on your experience, what are the main clauses, the main covenants that one should consider when drafting a distribution agreements with a German distributor?
Okay. One is related to the issue which we just discussed, the application of the agency law by analogy. So from the principal's perspective, it is important to decide upfront whether the distributor shall be integrated in the sales force like an agent or not. Such an integration can be of advantage to have a unified sales organization in different countries where we have strict guidelines. Then the principal will be closer at the customer base via the distributor. But the downside is that the distributor is then better protected like an agent, in particular regarding a goodwill compensation upon termination. Another important aspect, I think, is the European competition law, and in particular the EU regulation on vertical restraints. For example, the principal is not allowed to influence the retail prices determined by the distributor. This aspect seems to me to be not generally known. When I receive distribution agreements drafted by the parties themselves, I often see a clause that the distributor is not allowed to fall below the principal's sales price, for example, by more than 10 or 20%. The EU competition law is also limiting the possibility to agree on an exclusive sourcing of the contractual products with the principal or to prohibit sales outside the territory.
Okay.
But this is law in all European member states, so also in Germany.
Yeah.
Some very specific, in a very specific topic is our law on standard terms. Germany has a very strict rule on the validity of contractual clauses which are considered as standard terms. So we have to raise the question, what are standard terms in this context? Standard terms are deemed to exist if the clause is imposed by one of the contractual parties, often the principal, without being subject to negotiation. And secondly, if the imposing party intends to use the clause in several cases. So if you have a master agreement on your desk, then in Germany, we have to check the validity of the different clauses if the contract is subject to German law. So if a clause is to be considered as a standard clause in this sense, the provision must not unreasonably disadvantage the other contracting party. Only if the clause is individually agreed, the concept of freedom of contract applies. I think this is a very special issue in Germany.
Okay, thanks for pointing that out. And yes, we have a similar regulation in Italy, so it's good that we can keep this point in mind. You mentioned the issue of data being transferred back from and the say end customers' data being transferred back to the manufacturer, and a termination indemnity being a potential risk if you look at it with the eyes of the foreign manufacturer. I guess this must be one of the conflicts that tend to at the end of a contract. So maybe you want to, again, from your based on your experience, say a few words about this and ways to avoid it. Whether there is a specific contractual clause, for instance, that one may adopt to rule out this right.
You are absolutely right. The goodwill compensation is one of the main fields of disputes regarding distribution law in Germany. So it's all about, are the provision on agency law applicable by analogy or not? As I already mentioned, it's a question whether the distributor is integrated into the principal's sales organization like an agent. And to avoid such disputes, it is not sufficient only to include a clause that the goodwill compensation is excluded, because if we have the application by analogy, the goodwill compensation is mandatory. So we have to look very careful on the obligations which are imposed to the distributor to avoid this integration in the sales organization.
Okay, thank you. And if you had, maybe we can wrap up on this note. If you had to advise a foreign lawyer or entrepreneur on the best dispute resolution clause that they should, foresee in their agreement, what would be the most effective method that you would recommend?
So if I advise the German distributor, I always recommend the jurisdiction of the German state courts. I'm very much in favor of our jurisdiction here in Germany. Court proceedings in Germany are, from my point of view, compared with other countries, rather cheap and quite fast. It is not unusual to get the first judgment or the judgment in the first instance issued within 1 year. I think this is quite fast.
Oh, yeah.
Also compared with Italy.
Well, it depends on the courts, but yeah, we would be in the range of 1.5 to 2.5
Okay.
years, yeah, average. So it's not too bad.
Good to know.
Mhm.
And if the parties cannot agree on the specific state court in Germany, but prefer a neutral forum, I recommend agreeing on an arbitration clause, either the German Arbitration Institute or the ICC, the International Chamber of Commerce, as you know. As known, an arbitral award is final and good to execute in almost every country. The negative side are the higher costs and the risk for the losing party to be faced with a reimbursement claim for the real legal fees of the prevailing party,
Yeah,
which is not the case under German, the civil procedure law.
I see.
What I always try to avoid is to agree on German law and have a place of jurisdiction outside Germany. My experience is not very promising to
Mm.
have all German law evidenced by an expert on
Yeah.
this. This is so much workload and not very precise.
Yeah, I also always try to discourage such creative solution, right? Mixing jurisdiction, venue, and applicable law because it just gets things much more complicated. My very last question is whether you had any experience with mediation, which, especially in distribution agreements, where parties may have an interest in keeping to working together and not necessarily split up upon the raise of conflict. Did you witness mediation cases in distribution agreements, and what's the experience?
No, I have no experience with the institutional mediation. Of course, we tried to find a solution before initiating any proceeding. And in German state proceedings, in every oral hearing, it is also the duty of the judges to try to find an amicable solution. So this is of great importance also during a court proceeding. But I have not in-depth experience with mediation.
Okay. Well, maybe we will go back and discuss this, which is as I mentioned, a kind of a trend which is picking up
Mhm.
all over in Italy for sure. But I discussed this, for instance, also in the U.S. and in Spain. So we can go back to this for the moment. This is a good place where to wrap up. Thanks a lot, Julia, for the chat. And for those who would like to know more, we will provide Julia's contacts in the notes of this talk. And well, until next time, bye bye, Julia.
Bye bye. Thank you very much. It was my pleasure.
Sure.